One question I have for you, going on to Marshall, there's this preference for joint physical custody that exists in this statute, and I love when people cite it because I when I read the statutes, NRS 125C.0025 cites the preference for joint physical custody, and I read it as having actually limitation, and I want to get your opinion on that. But more so for post-decree custody issues, does that preference apply?
I don't think it goes away pretty much ever. Well, let's start with what is a preference. The word is undefined in Nevada law, and I've been to half a dozen seminars where people have asked judges, what the heck does this mean? Now, I know the guy who wrote that statute, and he just made it up. The short version was there is no definition for what a preference means. Most of the judges who've been put on the spot have said, we can't tell the difference between a preference and a presumption. So we're going to treat one like the other because we don't know what else to do with it. But it is an undefined word. I suppose, like all other undefined terms, it's going to end up in front of an appellate court at some point, and they're going to give it a definition. But that hasn't happened yet. So we don't. Nobody on this panel, I think, can legitimately know what the word really means. We should probably treat it as probably a presumption. Is probably the safest thing you can do with it. But it doesn't go away when you're talking about modification as opposed to original determination. It just continues to be there as something pointing the judges toward where they should go unless there's a good reason not to go there. So judges will have a predisposition to recenter on joint custody as their destination, unless you basically talk them out of it. That's probably the best way of looking at it, either in terms of an original determination or a modification, which is the subject of this seminar.
So, Marshall, I want to follow up with your statement and stick with you for a minute. So if we have an order that says the one parent has primary physical custody, you're saying that you could come back and argue this joint physical custody preference as a basis to seek a modification.
There's that old thing about the scales, and it's a scale. It may not be a 5-pound weight, but it's at least a feather that sits on the side of the scale leading toward joint custody as the judge is trying to make a decision. If the other panelists look at it differently, let me know, but I think it always acts as a drag on proceedings, as a targeting for the judge for where they're heading unless they have a good reason to go somewhere else.
I'll follow up. I mean, I think that's definitely a little bit harder if you are modifying from primary to trying to modify from primary to joint. Whereas at the beginning of every case, we walk in and I tell my clients, listen, the preference to me is also a presumption. We're starting at joint, even though that's not, technically if my client walks in and I think has a good case for primary custody, I will say to them, we still have a hill to get over because the courts start at joint. I think that hill's not as big if you have primary and are modifying to joint, but I would agree with Marshall that that's where the judges sort of always want to end up. And it depends upon what that reason for modification is. I think it depends a lot upon what the reason for primary was. If you had a stipulated agreement for primary physical custody that speaks zero to why it was primary physical custody versus a very detailed order. Mom has primary physical custody because dad XYZ, whatever that is. And if dad has overcome that XYZ, even if it's his work schedule doesn't allow for a joint physical custody and now it does, if the court has any inclination that, hey, we can push it over to joint, I would agree with Marshall that they're wanting to do that.
I think it's a good place. Go ahead, Michael. Yes, please.
I just want to weigh on this presumption v. preference because I have a slightly different take because it's a little bit of a pet peeve of mine. I'm surprised Marshall doesn't agree with me more. There's a major distinction, I think, between the two because in law school, we learn presumption has a very distinct legal meaning. There are legal presumptions used in other areas of law all over, the most commonly known being the presumption of innocence. And I think if we change that to the preference of innocence, that we would agree those two things are different. So I think we know what presumption legally means. And if we wanted it to mean that, we can make it mean that because we use that term all over in other areas of law. I do agree with my colleagues here that in practicality, that's the way it works. But as a fine point, this is why I was surprised Marshall didn't agree with me because he likes fine points. I disagree on the actual technicality of it.
And then just for our record, I don't disagree. I'm just saying it hasn't happened yet. One of us is probably going to be in front of the Supreme Court making that argument at some point. So I don't want this interview to come back saying, "Oh, you said there's no difference." I'm just saying there's no difference yet.
Well, and when I read the statute, I'll give my 2 cents here because I find the statute very interesting. There's a preference, but there's the word if, and then it gives 2 defining requirements. If you don't have any of those 2 requirements, is there a preference? I
Well-
feel like in practicality, the courts are treating it as such, but what if you have, there's not an agreement, but no, one parent's not withholding the other from the, or trying to inhibit the parent from having a relationship with the child, they just don't agree to joint.
And then I
Is
think
there a
Marshall would like
presumption or preference?
this in NRS 125.003, it creates these negative inferences that could be interpreted to mean if you don't meet one of those, that you have some sort of preference reversed that way too.
Right. It's the statutes are not clear, and I agree that we definitely need some more clarification, but I appreciate your guys' input on how it applies in a post-decree context, because I feel like that's not always been clear, and we're so focused on the Ellis factors now in every case. Are there other arguments to bring in? And I think that the stability argument balanced with the relationship with the parent, and then bringing in these preferences as well.